Hi everyone, this is Adam Cohen. I'm coming to you all today with another sort of edition of our academic and healthcare immigration updates from Siskind Susser. And today we're going to be talking to you all mostly about the executive order, more about this executive order suspending H, L, and certain J classifications, and we're going to be addressing some other items as well. So just want to point to you all to some resources that we do have on our website at www.visalaw.com and also on our Facebook page and other social media that relate to the executive order. And we've been trying to do these weekly calls to really do a deeper dive into the executive order, answer people's questions, etc. We do it in sort of a Zoom format with a few of our attorneys, and then we broadcast that to Facebook Live as well. We've really been very happy to see so many of you participating on this. So this past week we did one specifically on physicians in the new visa ban that you'll definitely not want to miss. Just talking about who the EO applies to and who it excludes, and also talking a little bit about some of the strategies for travel ban waivers, essentially, and who might be exempt from that classification. This Tuesday on July 7th at 7 p.m., we are also going to be doing a travel ban strategies discussion as well. So please feel free to join us. And of course, I'm trying to do these as often as I can, just kind of a weekly update. There was one that I did this past Friday that was a summary of executive orders. I find it helpful because I'm focusing in on the academic and healthcare side, that many of you are specifically looking for information about. And I'm also trying to do it in a summary fashion, for those who are on the go, busy, and maybe not able to tune into the full weekly call, just kind of recapping about that and even talking about other news that's not really even being covered on our topic-specific Zoom sessions, weekly Zoom sessions. So let's talk more about the executive order. There actually was an amendment that came out on June 29th. And before we do that, I think it's important to understand, who this applies to, the executive order. Just a little summary of that way you can kind of see the change, right? So we know that it is going to exclude H, L, and certain J classifications. The J classifications were like trainees and all pairs and interns and teachers, specifically the K through 12 teachers, summer work, travel, camp counselors. I might not have put everything in there, but those are the categories, and you can feel free to also go back to my prior summary about this if you'd like some more information about just the details of it. So it only applies to individuals who are outside the United States on the effective date of the proclamation. So that's very important, right? Does not have a non-immigrant visa that is valid on the effective date of the proclamation, also very important, and does not have an official travel document other than visa, such as a transportation letter, an appropriate boarding foil, or an advance parole document. Okay, so what has changed here? I think when people were looking at this second spot, they were thinking, oh, does not have a non-immigrant visa valid on the effective date of this proclamation. Okay, well, I have a valid B1, B2 visa, or I have a valid F1 visa, and it was valid on the date of the proclamation, which I think was on June 24th, or that's when the effective date, exactly. So can I now process my H-1B visa because I had an effective, a valid visa in A category? And basically the amendment shuts that down. So they're saying that, that the individual would have to not have a non-immigrant visa of any of the classifications specified in Section 2, HLJ, right, of this proclamation, and pursuant to which the alien is seeking entry that is valid on the effective date of this proclamation. Okay, so it shuts down those who may have been outside the U.S. and they had maybe a B1, B2, and now they want to go and apply for an H-1B. Okay, but notice here that it's the and that I think is very important. So what about the people who were inside the U.S. on the effective date of the proclamation, and now they need to travel? They want to leave the U.S. and they want to process an H-1B visa. Under the language of this executive order, it would seem that by the plain language, that they would be allowed to do that. They would be allowed to leave and they would be allowed to process that H-1B visa, right? Because they were not outside the US on the effective date of the proclamation. And that's sort of been a topic of discussion among immigration lawyers and others to try to figure that out. But the problem is that the State Department took to Twitter, over the last week or so, and they were basically saying that they're not issuing H, L, and certain J visas until the end of the year. So they're essentially ignoring the plain language of the executive order. And they went and they did this amendment, and they still did not, there was no patch to that. There was no amendment to the and portion of that language. So it's something that's very unclear. And I mean, on the doctor's side, we know that there are thousands of, not thousands, but a couple hundred physicians who have been impacted by this. There are physicians who are coming to do their training in the US. They're coming to do their graduate medical education, residency, and fellowships on H-1B, and they are not able to, some of them are not able to get an appointment still, even though they're supposed to be given some priority in terms of expediting at US embassies and consulates. Some of them are just not getting those interviews. And others are either getting refused the visa, or they're being basically, it's similar, but they're being put into an administrative processing, which is just a period where sometimes it's, they can't issue the visa for a particular reason, oftentimes tied to security background checks, but probably not in this case. But in other words, the embassies, they don't know, they're not receiving the guidance that they need to make determinations. So that's the problem with all these individuals who are supposed to start training the 1st of July, or sometime in this month, and they're not able to come for their H-1B. It doesn't impact J1, the J1 alien, what they call the alien physician category, for trainees who are coming on their J1, which most of them do come on J1. But the problem is that many of them are still not able to get their expedited appointments. So there's the two issues here. It's embassy closure just as much as it's this executive order. So I think that Greg Siskind had reported that he knew of 242 doctors stuck outside the U.S. Okay, so and if those of you who don't follow his Twitter, definitely should. He keeps it very up to date, and so look him up on Twitter for all the update information, including with respect to physicians. So there was also a new AAMC survey that came out recently that is projecting a shortfall of up to 139,000 physicians by 2033 due to retiring doctors and older patients as well. So I think it's very important to contextualize this. You have doctors outside, and I point out that some of them are training, but others are getting ready to start their post-training jobs in the US. They've secured a J1 waiver, and they went outside to see family, and now they're trying to get their H-1B status, H-1B visa to return, and they're getting stuck as well. So it's trainees, but it's also physicians. Okay, so it is that impact, and it will have certainly a profound impact on their patients as well. So we have these projections of a shortfall of 139,000 physicians by 2033. And that is actually up. I think the AAMC has done this survey pretty much every year. And they had predicted this past year was a shortfall of up to 121,900 physicians by 2032. So it's just these growing numbers. And so it's thinking about those numbers in the context of banning doctors from coming into the US, keeping thousands of others from getting green cards. There's been some legislation that would help eliminate the physician green card backlog, but that has not passed yet. We'll see what happens with that. But there's still, currently people waiting for green cards for decades, physicians even too. And, just a physician immigration system that is just not modern. A Conrad J1 waiver program that's very old, very outdated, and doesn't keep up with, modern demand for foreign national physicians, international medical graduates in this country. There is a possibility of litigation here, and the American Immigration Lawyers Association may take up a lawsuit as well. I will note also that Greg Siskind, I'll try to post these links too, but he is seeking the interest of individuals in being part of litigation. So our firm is very interested in individuals who want to fill out forms related to litigation of the April proclamation, the immigrant visa suspension, essentially, or green card suspension, and this most recent executive order as well as those who are interested in talking to reporters, really just trying to draw a light on these issues that are happening. There's a lot of family separation issues. It's really quite heartbreaking, and these stories need to be heard. They need to get out there. Another thing that came out, I think it was this week as well, but there's been a Gallup poll that has been basically updated for the last 55 years, I think, related to the feeling of Americans in terms of increased or decreased immigration. And 34% of Americans, up from 27% a year ago, would prefer to see immigration to the US increased. This is the highest support for expanding immigration that Gallup has found in its trend since 1965, okay? So there is also the percentage favoring decreased immigration has fallen to a new low of 28%, while 36% think it should stay at the present level. And this is not all reactionary to what has happened with the DACA decision, what has happened with the executive order. This was data that was collected between May 28th and June 4th. Okay, so it predates this executive order and many of these recent things that have come. But there are very positive feelings toward immigration either being increased or maintained at current levels. And think about that in terms of the Clinton administration back in 1995, when 65% of Americans wanted immigration decreased. And what did you see from that? You saw a lot of the unlawful presence bars and some very restrictive policies, during President Clinton's term. So there's been a lot of changes here. But there's all this immigration restrictionism at a time that people want increased or at least maintained, immigration maintained at its current levels. Let's move on to a few other topics here. So there is the potential for a USCIS furlough on the horizon, of them furloughing perhaps 70% of their workforce if Congress does not provide them with emergency funding. So USCIS is a fee-funded agency. That's how it pays its workers and maintains its infrastructure, is through fees primarily. Over the past 2 years, the USCIS operations have swung from a yearly surplus to a massive deficit. And that has been due, frankly, to mismanagement and misallocation of funds. There's been sort of this usage of a benefit granting agency, even for enforcement actions, even though it is not an enforcement agency. So it has really been, it has not followed suit with its original purpose and mission, and that has also resulted in this massive deficit. They have asked Congress for, this was back in May, for $1.3 billion to support operations. They started announcing their furloughs 30 days in advance of when they go into effect. Now that's required by collective bargaining agreements for the unions of the USCIS officers. So if this does occur, and groups like immigration advocacy groups and groups like American Immigration Lawyers Association are saying, don't just give them a blank check, for $1.3 billion. Let's get a little bit more transparency and efficiency into the agency, and to stop this mismanagement, of its funds. Okay, some better oversight of its funds. But anyway, if they don't get the funding and these furloughs happen, it could slow down the processing times dramatically. Okay, so you could still likely just file the petitions as usual, but it would then slow everything down, which has already been very, very slow. There's even was a congressional hearing about this at some point, just due to the USCIS really being quite outside of its intended processing times, and those processing times just elongating across the board in many types of benefits. So something to look at then is the furlough that's potentially on the horizon. So I put the doom and gloom of the spring 2020 regulatory agenda. This is something that's put out by the various departments the executive branch, related to what's on their agenda in terms of regulations. It's more of a wish list. So, I will tell you all about some different proposals and things of that sort, but keep in mind that this is a wish list. There's nothing that has been finalized as of right now of the proposals that I'm mentioning. Okay. So Department of Homeland Security, of course, no surprise, they have most of the regulatory agenda items. And I'm just reading the ones that are relevant, I feel, for the academic and healthcare community. There are many, many others. So one of them is to strengthen the H-1B non-immigrant visa classification. They want to revise the definition of specialty occupation to increase focusing on obtaining the best and brightest foreign nationals via the H-1B program. Now, we talked about this just in line of potential, in this executive order that recently came out, there is some vague language to maybe doing some regulations. And this has been previously published or previously listed in the regulatory agenda, this desire to change, restructure the H-1B program. They're also talking about revising the definition of employment and employer-employee relationship to better protect U.S. workers and wages, is what they're saying. So I would also point you all to probably the first one I did of these a couple of weeks ago that was talking about the IT Serve Alliance litigation and the resulting need per the settlement for USCIS to rescind a few of its policy memoranda. This may be their way of trying to get their restrictive definitions of employer-employee relationships and what equals control, back into the back into usage through this regulation that they would try to get focused on. So let's just look at that as well. There'll also be, they're still looking at removing H-4 work authorization for dependent spouses. There's really no surprise there. That's something that we've also been discussing and hearing might come out. And we're not sure whether these are coming out as, it doesn't say anything about interim final rules here or anything like that. As of right now on this regulatory agenda, I don't see anything where they're trying to exercise a good cause exception to get these regulations implemented faster. We will see. It's just H-1Bs and H-4s still on the agenda. They do have a few regulations here that they're trying to get through about redefining how unlawful presence accrues or clarifying that, and also the establishing a fixed time period of admission and extension of stay procedure for non-immigrant academic students, exchange visitors, and also members of the foreign media. So this is impacting, potentially F, M, and J, as well as I, which is not, those are the media, that's not as relevant to this community. But, modifying the period of authorized stay from the duration of stay classification that F, M, and J categories receive to something that is more date limited. And that made headlines a few weeks back because that's been sent to the Office of Management and Budget, I believe, for that regulation. So it's very much in, something that they're wanting to do. This is no doubt, the White House's response to litigation overturning the unlawful presence memo for F, M, and J, which would have completely restructured policy over the past 20 years by installing these very harsh consequences for those who, did some type of unauthorized activity as judged by an officer later, for those who were in F, M, and J, and sort of having them face these extremely difficult consequences of unlawful presence without really understanding whether they had violated, had triggered some type of violation. So there's this is their way to recalculate unlawful presence and to, really try to end the duration of stay, which would have significant effects timing-wise. It would have effects fee-related wise for universities and for students. We'll talk more about it if it comes to fruition, but it's something that's definitely on their radar. There's also practical training reform to amend regulations and revise practical training options available to non-immigrant students on F and M. Not entirely sure what this could mean, but there have also been reports that the White House will seek to remove STEM OPT, rescind STEM OPT, to maybe limit standard 12-month post-completion OPT in certain ways. Again, there's nothing here. This is a regulatory agenda item that has already been in existence. It's nothing. It's very, very vague in terms of what they want to do. They do want to adjust program fees for the student and exchange visitor program. Now, this is something I thought that was interesting in that part was that they said ICE has determined that increasing the fees is necessary to support increased compliance, including worksite enforcement, investigating fraud related to non-immigrant employment, and enforcement regarding non-immigrant students who violate their status. The whole worksite enforcement part I thought was interesting because, recently there's been this increased conducting of STEM OPT site visits to make sure that employers and students are in compliance. So it could be a reference to, their desire to now increase fees to further fund and support that site visit program for STEM OPT. So that's an interesting thing that I would bring to your attention. One item that has not made it back into the regulatory agenda was an item I think that had been on in varying forms for a few years now, which was to review the standards related to J1 waivers. And that has been removed. So that's some good news, at least, that we have. So let's just talk briefly about the USCIS response grace period has been further extended. They have been giving this grace period to responses to RFEs and notices of intent to deny and things of that sort. And they have, there's now been a further extension. So they will consider a response received within 60 calendar days after the due date set forth in, they say the following requests or notices before taking any action. If the request or notice was issued by USCIS between March 1st and September 11th, 2020. So they are basically extending, it's a 60-day grace period to respond to requests for evidence, notices of intent to deny, etc. And they also have, there's also a provision there to extend notices of appeal or motions to reopen. And I think that is, they also say if filed 60 days from the issuance of a decision by USCIS. Okay, so they're providing, usually you have about 30 days to respond to a denial. And so it's an additional 30 days here. And it says if such decision was issued between March 1st and September 11th. Okay, so some other good news there, procedural news. So the last thing I wanted to talk to you all about is just this, the J1 Exchange Visitor Program. There were some updates that came out recently. So on June 25th, and just try to be brief on these summaries. I'm kind of learning with you all as I go as well. There's been so much that's been happening, so bear with me. The question was, can exchange visitors participating in the teacher, professor, and college university student categories of the exchange visitor program teach, take online hybrid classes in the academic session starting this fall, or must all courses be in person? And the distinction basically that they drew was between new exchange visitors being put into initial status in the Student and Exchange Visitor Information System, the SEVIS system that basically monitors compliance for these individuals, for initial status versus active status. So those who are in initial status, they can start their exchanges only if the programs and host institutions can follow the regulatory requirements, which mostly deal with in-person requirements, okay? So in-person teaching by professors, in-person attendance by students. There is some flexibility that could be allowed, they say, in permitting a limited amount of distance learning, but they're looking for at least reinstated partial to full-time classroom participation in the fall for J1s. Now, those in active status, they can basically continue on with the program's alternative ways to maintain program objectives, including online classes or other arrangements. Okay, so they're basically giving a nod to adjustments and alternatives already presented over, since this pandemic really, started to spread here in the U.S., really took hold, the actual pandemic itself. And so basically those programs that those alternatives can continue to be in effect. but it's the issue is for the initial students where there is a much more limited degree of flexibility. Speaking of which, we're still waiting to hear from SEVP, Student and Exchange Visitor Program, about the F1 and M1 students who have also, since the pandemic, the schools have been able to make adjustments, and if the students were in compliance with those adjustments, such as distance learning, that was okay. We don't have any guidance yet from SEVP about F and M students for the fall, so look for that as well. The last thing is the Department of State made this announcement about an optional one-time opportunity for a 60-day extension for exchange visitors in the academic categories whose programs end between May 1st and July 31st to allow the continuation of those programs if requested by sponsors until the safe repatriation of exchange visitors can be arranged. Okay, so this is for individuals who are currently in a J1 academic program who cannot go home. They're just unable to actually go, maybe related to closed borders or the inability to get flights, et cetera. So exchange visitors, basically the sponsors are supposed to reassess the plausibility of the exchange visitors in the academic categories returning to their home country once their program ends within the next 2 months. Sponsors should submit requests for this one-time 60-day extension in the SEVIS system for all interested and eligible exchange visitors. Okay, and there's additional justifications they do have to provide to the U.S. Department of State. And if this is granted, this 60-day extension, they would reprint the DS 2019 with the new dates and provide that to the exchange visitor. So that's some, at least just kind of some welcome news there. So hopefully that will be helpful. And that is everything that I have today, everyone. So there's so much to cover. There's even more that I wanted to put on here, but I want to keep this at least a brief length, less than 30 minutes. So thank you all for tuning in. Take care. And happy 4th.